Good afternoon. My name is Rashelle Fetty, and I am one of the Texas legal member attorneys located here in Colleyville, Texas. And I'm going to be talking to you about premarital and postmarital agreements today. First, I want to let you know a little bit about Texas Legal. It's a statewide nonprofit legal benefit plan founded by the State Bar of Texas and the State Legislature in 1972 in an effort to better meet the legal needs of Texans. Texas Legal provides members access to over 500 network attorneys, just like myself, and Texas Legal offers various plan policies. Contact information will be in the comments and description box of this webinar. With Texas Legal, members are able to create either a prenuptial or postnuptial agreement once a plan year. Texas Legal has you covered, so please contact Texas Legal for more information on plan benefits. All right, now for premarital agreements. I'll talk a little bit about kind of the basics of these types of agreement, premarital and postmarital, and then it's really best if y'all send your specific questions and I can give you better information. Lawyers are trained very, very well to always deal with specifics, right? Everybody's individual case really makes a difference on what information we give out. So I'll give you the general stuff, and then y'all let me know what specific things you're curious about, or maybe you've heard and you want to see if that's true or not, and we can go from there. So for premarital agreements, the requirements are that the agreement is in writing and signed by both parties. So it's essentially a contract between intended spouses. And so you can contract around almost anything that is legal, which includes death and wills. So you can say in your premarital agreement what will happen when one of you passes away. The only thing that you really can't contract around in a premarital agreement that you would think you can is child support. So if there are children of the marriage, you can't say, I'm never going to pay support, or somebody's going to have to pay $5,000 a month in support. Can't do that. Now, the agreement does not become effective until you actually get married. So you sign it before you get married, and then once you actually get married, then it becomes effective. Now, other ways for it not to be enforceable are kind of difficult, but they exist. So if someone didn't sign voluntarily, then it wouldn't be enforced against them. But proving you didn't sign it voluntarily is pretty difficult. So something to think about. Another way is if the agreement is unconscionable. It's a legal word. It basically means so unfair that it's just outrageous. Okay, and so it has to be pretty bad. And also that the person that signed this really terrible agreement didn't get a fair disclosure of the property and debts of the other party, that they didn't voluntarily waive the right to the disclosure. So sometimes the document will say, well, pretty much always it says right in it, yes, I got all the disclosure that I needed. Or that they didn't have knowledge of the situation and they couldn't have gotten knowledge of the situation. So you're kind of required to do a little due diligence of your own before you sign one of these. And if you don't, and then you want to say, hey, this isn't fair, it's a little bit your own fault. So ask all the questions that you have before you sign a premarital agreement. Okay. All right. So then we have the postmarital agreements. They kind of have a bunch of different names. So there's I mean, people say postnup, but that's not really a word that's in the laws. But it covers the other things. So what the way the law phrases it is that it's a partition and exchange agreement, and you can turn community property into separate property by an agreement, in writing and signed. And then you can also do the opposite. You can convert separate property into community in a writing that's signed. With that one, you have a little extra requirement. You have to be specific in identifying the property that's being converted. But it's still pretty easy to do. That one thing that I think people kind of assume sometimes is that transferring property from one spouse to another makes it community property, but it doesn't. The law presumes that that was a gift, and gifts are separate property. So then on these agreements that people enter into after they've been married, the enforceability process, I guess, is the same as a premarital agreement. If you didn't sign it voluntarily, or if you didn't have disclosure of the information, it might not be enforceable against you. And then another issue that comes up with these things are creditors. So you cannot use any of these agreements to cheat, basically, a creditor. And that's something that people ask about a lot in the kind of divorce process, is like credit cards, or any kind of debt, really. Are you liable for your spouse's credit cards? Can you make them pay your credit cards? Those types of questions. So those are contracts as well. So a contract that was entered into with a credit card or a car loan or anything like that, the family laws don't really affect that much, because the judge isn't a party to the contract, and that wouldn't be fair. So those things, contracts are not affected by premarital or postmarital or even divorce agreements, because that wouldn't be fair to the creditor. They don't know anything about it. So, all right. I mean, those are the basics of how a premarital and postmarital agreement works, what you can and can't do. So if y'all have any questions, please let me know. I'd be happy to answer. While I'm waiting, maybe for y'all to type your questions, I can tell you some of the most common terms that go into prenups. Most of the time, people will say, we want all of our property to just stay separate. We don't want to create any community property. And you can absolutely do that. Oh, okay, here's a question. Fiance want to combine bank accounts. Would it be an issue when one thing, our income, isn't community property in the case of a divorce? So right now, as fiancés, there's no community property yet, and so with a joint bank account, say you need to divide up, right? We've broken up, and now we've got this joint bank account, and what are we going to do with it? I mean, I think that you would look at who has contributed what to the bank account. In a practical sense, most people are probably just going to split it and go on about their business. But so that's, y'all are fiancés. So it's not a community property issue yet. Right now it would be, just who put what in there. So then once you get married, then, all of everybody's income is community property. All income is community property. Whether I make, $50,000 a year and my spouse makes 200, it's all equally ours. We have $250,000 to spend. So without a premarital or postmarital agreement, when you go to get divorced and you have a joint bank account, even if they're not joint bank accounts, if you have your bank account in your name and your spouse has theirs in their name, if y'all have 10 bank accounts, any income that has been earned during the marriage that's in those accounts would be subject to division, generally 50-50. Now, so if you're saying that you do not want your income to be community property, then you can absolutely write that into your premarital agreement, and you can have the terms lined out in advance for exactly what you're asking. What happens when it comes time to get divorced? What do we do with our bank account? You can absolutely decide that up front, put it in the premarital agreement, and whatever y'all have agreed to, 10, 20 years down the line, when it comes time to get divorced, then you follow that agreement. So you can have it say whatever you want to. You can have it say that we split it 50-50. You can have it say that it is determined by who put in how much, and whatever interesting things you can dream up, you can put in there. I hope that answers that question. And then I see there's another one. How often can a prenup be updated? Anytime you want. I mean, you can revoke them, you can revise them, you can do pretty much whatever you want there. And so say, the reason that you need to update is because you weren't thinking you were going to have children when you got married, and then now you do. I mean, you can put some provisions in there for custody type stuff, but again, remember, you cannot contract around support for children, but you can put other children related provisions in there, or if income between the spouses has changed a whole bunch, you can definitely revise the terms. And some people, a lot of the times, what they'll do is they'll say, like I mentioned earlier, the prenup says we don't want to have any community property created, right? But then they'll say, except for, we're going to have one joint bank account that we each contribute. Sometimes people will say a certain dollar amount every month, like, we're each going to put $2,000 in that account every month. And then, that'll be how we pay our bills. Or sometimes they'll say percentages, like, spouse A is going to put 40%, spouse B is going to put 60%. So if you had something like that in your agreement, and then spouse B that was paying more, their income goes down, and so you want to make it 50-50, you can absolutely do that. Or if there's a big flip-flop and you want to go, spouse B is doing 40 and A is doing 60 now, sure, absolutely. It's y'all's agreement. You can change them whenever you want to, and use it however you think you need to. So anyway, all right. I don't think there's any other questions. So I hope this was informative for y'all. Maybe you learned a little something. Hopefully proved the Google search wrong here or there. So thank y'all for joining, and have a great rest of your day.